account.
Perfect, perfect. Well, I'll do that. Well, welcome everyone. Thank you for your patience with our, little bit of technical difficulties. I hope everyone's Thursday is going well. Greetings from upstate New York, where I sit. I told folks that today is the kind of day where you can experience all 4 seasons in one day. And right now it's about summertime right now, but a little bit later it'll be more like fall. So we are looking forward to having everyone kind of join us for this third installment of protecting your ministry through risk transfer. So this one is all about client and volunteer risks through waivers. And I will tell you that, most clients and most volunteers, there's not an issue, but, there's 1 in 100, 1 in 1,000 that can turn out to be a really significant issue. Fielded a claim yesterday of a guy who fell off a bunk bed. Turns out he had a significant heart condition. He never would have been put in the second bunk if he had disclosed that, but he didn't. I know of another time where a pastor's son was volunteering at a ministry and he was cleaning up trash and he got stuck with a used needle. That was a very uncomfortable situation for everyone, physically and logistically. So it's a very real issue, and we're trying to work together to be proactive. So Sara, our wonderful risk control consultant, is going to walk us through this presentation. We encourage you, turn off your video. You can turn off your audio as well, but please feel free to butt in either in the chat or just verbally and ask a question or ask clarification. And, our goal is for this to not be a lot of insurance speak. We've encouraged a lot of folks who are actually, volunteer coordinators or working in client intake to attend. And this is, designed to be, as much as anything, kind of a primer to the idea of transferring a little bit of risk and protecting the ministry for the clients walking through the doors to stay with you, and also the volunteers who are there to be a part of the ministry. So that's probably a long enough introduction from me. So Sara, I will try to get to the next slide. And,
Awesome.
I think of anything else you want to say on this?
That was a perfect introduction. So thank you, James. I really appreciate it. And hi, everybody. So as James said, there are a lot of risks involved with just having volunteers running programs for lack of a better word, and apologies if you use different vocabulary, but we'll call them clients, our participants, the people you serve, that are just outside of our control, and they're inherent risks. And what waivers, what we want to talk about today is how waivers can protect your organization from some of those inherent risks, what some of the pitfalls of waivers are when they do work, when they don't work, as well as some best practices for when your organization goes to draft liability waivers, draft liability signage. And we'll also, in a follow-up email, be sure to get all of you guys templates for standard liability waivers for special situations where volunteers might be driving for your organization. For example, if they're delivering meals, as well as permission slips, or if you're doing any activities with minors and we need to get parental consent. So I know we'll probably, like our other presentations, throw a lot of information at you guys. It might feel like drinking through a fire hose, but I promise you, we're not just here to create worries for you and then give you a to-do list. We are here to help you through this whole process, and that will include getting you guys resources so you can take these, review them with your legal counsel, and make your own so they're a good fit for what it is that you're doing. Awesome. And you can go to the next slide, James.
Sounds good. I heard the verbal cue, and up there we go.
That's okay. I'll go to the next slide. Okay, so just first and foremost, to start off, why use a liability waiver in the first place? And this is to create a contractual protection for your organization. So what you're doing is having a person, a third party, not an employee, because if employees are injured or something goes wrong while they're working as part of their job duties, that is covered by workers' compensation, which is a completely separate jurisdiction than civil courts where lawsuits might be filed if someone was injured. So this is for third parties that are either, again, you're doing work for your organization as a volunteer, or are a client of yours that you're having a program for. And what they're essentially doing is assigning an agreement that says they understand what they're doing has inherent risks, and that they are agreeing and they're voluntarily accepting those risks, and that they are releasing your organization from liability for injuries or property damage that they may sustain from those inherent risks that they knew about going into it. So it is a contract. It is a legal document. So I do recommend having your attorneys review them, because every single state has its own unique set of laws. And you just want to make sure that the document, again, the contract that you have is to the fullest extent permitted by law. It will hold up in court. But we will talk about general best practices today and what we've seen from a claims perspective in terms of what has worked and what hasn't worked when lawsuits have been filed against clients that we represent. And I will say, I know it sometimes feels counterintuitive to the spirit of nonprofits and ministries when you have volunteers sign waivers, because they're doing a great service for the community. They're doing a great service for the organization. However, I have seen fraudulent claims made. I have seen claims made against an organization that they really shouldn't be responsible for. And so to be on the hook for that could end up, putting either out of pocket dollars towards that loss for the organization, or having insurance premiums increase because of a claims history. And that's money that would be, better spent and better served, going towards the programs, going towards the people you're trying to serve. So it isn't that we're trying to say, we don't want to be responsible for anything if you volunteer for us. It's simply, we want to create a layer of protection so that if there is a fraudulent claim, if there is an incident that occurs that was outside of our control, that our organization isn't going to be responsible for something really where we shouldn't be responsible.
Okay.
And Sarah, if I can butt in a little bit as I try to get to the next slide, it's, a lot of times I get asked, James, can you send us a sample that other ministries use or that you have on file? Well, no, I'm not an attorney. Your attorney needs to review it, kind of like you said. But, because this is so state specific, if one ministry, say in Florida, had a waiver that their attorney used, are the odds that this could probably be used by another ministry in Florida if they wanted to share kind of ministry to ministry?
Yes, odds are good that it would be. And really, for the most part, most of the states have the same essentially set of rules. And the reason why it is so especially more important for waivers than maybe a typical contract is because when let's say you're signing a contract with a third party organization, that organization likely has an insurance policy with an insurance team. They have a legal team. And so they're expected to have a level of competence when it comes to signing agreements and understanding what they're signing. When it comes to having individuals sign these types of contracts, they're not expected to have the same type of knowledge or have the same resources to be able to review contracts. So that's where a lot of these contract laws with waivers, and again, I'm not an attorney, so this is just information coming from attorneys that I've spoke with and claims adjusters, but where a lot of these laws come in, or certain language needs to be in there because you're, again, the people who are signing them don't have resources. They may not be as familiar with contract law. So it does need to be more plain. Certain verbiage does need to be in there. So the templates that we send out from, just the national claims perspective, it tends to be, and sometimes I laugh because there are 2 pages and I'm like, why is this? We're stating the same thing 10 different times. But that's because we are trying to fill in some of those gaps for different states that may require different things. So yes, so sorry for the long answer, but so the short answer to your question is yes, I would assume it is safe so long as it's with the same, so long as it's in the same spirit. So for example, if you got a waiver for an event participant or one that you used in a contract that involves a third-party organization, I would not say that you could take that same language and apply it to individuals, but as long as it's in the same spirit, so it's, a volunteer waiver, that would be safe. If it's an event liability waiver, that would be safe. But once you break out into those different sort of niche risks, that's where I would say maybe just review it, or at least broaden it, maybe or even reach out to us to see if we have experience in that area.
Great.
Okay,
Thank you.
Yeah, absolutely. So now I'm just going to jump into some common misconceptions about waivers, because sometimes in talking with clients, I do find that there are some. And the main one is that a liability waiver does not prevent a lawsuit. Even if someone signs a liability waiver, they can go out that same day even and file a lawsuit against the organization. And it does not necessarily mean that a judge is going to dismiss the case instantaneously just because that waiver is signed. What it really does is creates a layer of protection and shifts the burden of proof to the person who signed the waiver. So what I mean by that is like we talked about, there's inherent risks if you're doing volunteer activities. So let's say, for example, the volunteer activity is to stack boxes on shelves. There was a food bank drive, and now we're going to store the food. There are risks with boxes and putting them on a shelf. If someone doesn't have a liability waiver and has an alleged injury from lifting those boxes, they could say, well, I had no idea that how much work was going to be involved, that these risks were there. I did not know by volunteering I could possibly be injured. I was doing this out of the kindness of my heart, and now I'm making a lawsuit and claiming damages, whether it's medical costs, lost time from work, lost enjoyment because of the injury. And so what having them sign that liability waiver does is get it on paper in writing that they knew that there were risks involved. They voluntarily accepted those risks, and they agreed to release us from liability. So now that shifts the burden of proof to the person filing the lawsuit to have to show the court, okay, the reason I was injured is not because of some inherent risk. It was because of gross negligence or willful misconduct or something so egregious that there's no way that I could have known that risk was going to be there. So that's how it lessens the liability and puts us in a much easier position to defend a liability claim if we have a waiver versus if we don't have a waiver. It's also just good up front to let volunteers know, we appreciate your time, but this isn't, there is some risk that is going to be involved. Are you willing to accept that? I think it's good just up front to make that clear when forming those relationships. And then another, like James and I had just talked about, waivers are not always enforceable. That's also a misconception. Some people, sometimes organizations think they can just write down a simple sentence of, I promise not to sue the organization, have them sign it, and that will work. Like we just kind of talked about in detail, different states have different rules. These people signing them are not expected to understand insurance jargon, such as the term indemnification. So you want to make sure that your waiver it has the proper wording, that if there are any specific state laws that you're accounting for those. And then finally, a lot of times people think waivers apply to any type of claim. That also is not true. So waivers are good for, general bodily injury, general property damage. But there is federal laws that prevent people from signing waivers for things such as claims for sexual abuse and molestation. So again, the waivers are good for that general liability, that third-party bodily injury or property damage, but there are going to be some specific risks that the waivers just will not apply to because it's in a different category. It's a protected type of claim.
And Sarah, are there other protected types of claim we should know about in this space? I know you mentioned like physical or sexual abuse. Anything else that could be alleged in this space that we might want to know about?
That's the biggest one. I mean, you can't also,
okay.
If someone has a claim for discrimination, if they feel like they're being treated differently and they had some type of harm for it because of they're in a protected class, such as racial discrimination, those also in general really can't have a liability waiver to waive that type of liability. But I would say sexual abuse and molestation is probably the biggest one we see in the ministry and nonprofit world. But yes, discrimination would also fall under that umbrella.
Yeah, and I mean, and that's important to know, because I think sometimes we can be concerned that, oh, maybe someone who claims a different religion or a different orientation, sexual orientation, might try to challenge the ministry in that way. So I think that's a good note.
Thanks, James.
We ready for the next slide?
Yes, we are.
All right, here we go.
Okay, so now we're just going to go over some of the key items to include in the waiver. So the first one is an indemnification or release of liability clause. For those who may have not joined the first two sessions, indemnification is an insurance and legal term that essentially just means one party agrees to cover any damages the other party may incur or suffer from an incident that arises from the agreement. So I know that that's a mouthful, but essentially it's one party saying, okay, we're signing into this agreement, let's say for a volunteer program, and I'm going to agree to hold you harmless, not come after you. And then if I suffer any damages or cause you any damages, I will be responsible for that if it arises from the volunteer program. So it is key to have that in there and make sure that there is specific wording that they agree to release your organization from liability, that they agree to assume the risk, and then of course including the insurance jargon that all the attorneys are going to be looking for, which is to agree to indemnify and hold your organization harmless. Another key thing to put into waivers is acknowledgments. So like I talked about, we need a written agree or something in writing that says this person knew there were inherent risks with the volunteer activities, or if it's a client with the let's say you're doing an event, that they understood that there were inherent risks by attending that event. So it's just good to put it in the waiver that's just simply put, I understand there are risks. We'll have some sample language later. Usually it says up to and including bodily injury and death, which I know sounds scary, and most volunteer activities actually, the chance of that is very low, but that is the language that's recommended to be in there, because it is important for people to know that anything can happen. You also want to make sure for volunteer waivers that there is an acknowledgement that they know that they're not employees and that they would not be paid. It's pretty rare for it to happen these days, but I have seen some instances where people were volunteering. There wasn't a waiver, really type of an agreement in writing, and then they later tried to claim that they thought they were going to be compensated, given some type of stipend, and that they then should be entitled to workers' compensation benefits because they were working for the organization. So just to avoid those potential pitfalls.
We definitely see stuff like that with clients in the program, especially since so many of our programs have work therapy. Most clients understand they're not getting anything, but yeah, we've definitely seen some allegations along that. Oh, I was an employee. Yeah.
Right. And exactly. And you don't even have to have them on your payroll for them to make that claim that they're an employee. So getting it in writing that just says, hey, I understand I'm not an employee and I'm not going to be paid is key, just to establish that baseline. And then, I think that was just some crosstalk. Okay. So then the other one is although, again, it sounds redundant, but you also want them to acknowledge in writing that they understand that you're not responsible for any injuries or property damage. And again, just for those states that say, hey, did this person signing it really understand what they were signing? So we just want, in addition to the fancy insurance jargon that all the insurance adjusters and attorneys want to see in there, you also, we recommend just putting in plain English, you understand that we're not going to be responsible.
Good. And that's property damage that someone could cause to the ministry or to someone else while volunteering, like damaging another volunteer's car. Is that the right thing?
Yes, exactly. Yep. That we also, in addition to bodily injury, we want to protect against those types of incidents as well. Even things that seem as silly as, if they had their cell phone, and they dropped, someone bumped into them and they dropped it in water, that type of thing. We we want to have it be a broad umbrella so that it can cover any situation, because right when you think you've seen it all, something happens. You remember how much it is you don't know, and it's never a day in the insurance world, that's for sure. We see all kinds of claims. So the next couple of key items we want to go over are, and we've talked about this, the clear and conspicuous statements. Again, just putting things in plain English. In addition to the things we've already talked about, we also we want to put in plain English that people agree to be financially responsible for costs incurred for medical care or treatment. A really common argument we see in lawsuits, even when there are waivers, are that, well, we knew that we were holding you harmless, but we just assumed that you had insurance to protect us. We just assumed that if we had medical costs, that it would be covered. So to avoid those assumption arguments, that's another thing we want to make sure is in those waivers, is that if any medical costs arise from an injury they sustain while volunteering or while attending an event or a program, that they agree to be financially responsible for those costs. And we'll talk about volunteer insurance a little bit at the end and how that plays in. But just for a quick snippet now, volunteer insurance is a out-of-pocket cost reimbursement. So if you have it and a volunteer gets injured, their health insurance is going to be primary. Whatever out-of-pocket deductible they may have, a volunteer accident policy will cover those out-of-pocket expenses up to the policy limit. So if it's, for example, $5,000 and the person has $6,000 of out-of-pocket expenses, unfortunately, it's only going to cover that first $5,000. But again, it's a reimbursement. It is not an insurance coverage. It is certainly not a health insurance plan. And so even if you have volunteer accident insurance, it is still critical to make sure that you have it in your waivers, that you're not going to be, that they're going to be financially responsible, for any costs incurred. And then the last thing I recommend adding in, and this isn't necessarily from a legal perspective, this is more from claims, is to have them acknowledge or certify some statement in writing that they agree to follow all rules and instructions. Because I've seen claims arise where volunteers get injured and they were doing something that their volunteer coordinator specifically told them not to do. They went in an area they were specifically told not to go in, or they were doing something that maybe in an unsafe manner, and they were instructed, like for example, one case I saw was a volunteer said they injured their back lifting a heavy box, and the volunteer coordinator had supplied them with dollies that they should have been using, that they should have been on. Had they used that, they wouldn't have gotten injured by carrying heavy items all across the room. So I recommend including that just so we have it in writing that they agree to do that. And if they get hurt not doing that, if they aren't following the rules and that's what leads to the injury and it would have been prevented, it's in my opinion that the organization shouldn't be responsible for that. And it would put us in a good defensible position in terms of a claim if we were able to get it in writing that they agreed to follow any rules or instructions that were given to them. So now we're just going to go over some special considerations, because there are some unique situations that can come up with volunteers with running client programs. So the first one I want to talk about is if volunteers are driving as part of their volunteer duties. Most often, this is if it's a Meals on Wheels type situation. Like, let's say they're delivering meals to families. Other times they're delivering supplies, or they're transporting goods from one site to another for your organization. Sometimes they even transport people. Maybe they're taking senior citizens to doctor's appointments, things like that. So there are a number of situations where volunteers actually end up driving as part of their volunteer duties. And if that's the case, I recommend having a special waiver that has all of the standard language that we've already talked about, but includes a clause that has the volunteers acknowledge that they have a valid license, that they have auto insurance that's at least the state minimum. We'd prefer it to be higher limits than that, but at least have some type of auto insurance in place, that they have an acceptable driving record. And what I mean by acceptable driving record is what insurance carriers consider to be acceptable, which is typically not having a serious moving violation in the past 5 years. And serious is usually a hit and run, a DUI, something severe like that, or no more than 3 moving violations in a 3-year period. And that's just because if someone has a poor driving record, it's usually an indication that there's going to be incidents again in the future. And we certainly don't want the organization to be liable for a volunteer that's driving and their driving behavior. So that's why we recommend ensuring that they have an acceptable driving record. And then similar to following the rules like we talked about in the last slide, having them agree in writing that they're going to follow all local and state traffic laws. And in an ideal world, we would run NVR checks for all volunteers driving the same way that we would for employees as a risk management matter. But I know that that's not always practical. So at the very least, just having the waiver and having someone say, we'd love to have you volunteer if you're going to drive. Here's our criteria. If you don't meet it, that's okay. We'll find a different role for you, just so we can try and mitigate risk that way. Another note is if minors will be volunteering or participating. So whether they're going to actually be doing volunteer activities or whether it is a client that you are running a program for, maybe it's an after school care program, a Sunday school program, you want to make sure, and I know it sometimes seems like stating the obvious, but most states, don't allow minors to release liability on their own behalf. It has to be done by either a parent or a legal guardian. So when crafting these waivers, if you do have minor participants, people under the age of 18, or if you run programs for minors, just for programs for minors, I recommend just having a separate permission slip. If they're volunteering, you can have the same volunteer waiver, but instead of saying I agree, it's just I/my child. And then at the bottom, having it be for the signature for the parent or legal guardian. And then beneath that, just having a blurb about how they attest they do have a right to sign this waiver on behalf of their minor. And again, we'll give sample language. I just wanted to point out that that's key, and that if someone's under the age of 18, even if they sign a waiver, it's likely not going to mean anything in court because most states prohibit that.
Yeah, that's great. And I think for many of us on our insurance application, we do say, hey, if a volunteer is regularly driving their own vehicle on ministry purposes, and I think currently we understand regularly to be weekly, which is unusual, but does happen. We are making sure we're screening them and checking their personal auto insurance the same way we would if they were an employee. But if you have questions on that in your specific situation, you can talk to John or I, and we can talk you through it. That's definitely one of the most trickiest to insurance and compliance parts of ministry to navigate, I think.
Oh, absolutely. Thanks, James. That's great information to share. Appreciate it. The next two special considerations we're going to go over are fitness activities and then events. So for fitness activities, the inherent risks are just greater than an everyday volunteer job. So fitness activities could be maybe you have a shelter that has a fitness room that clients can use, or maybe you are hosting a basketball tournament, or you are a soccer tournament playing sports. Anything that has to do with fitness, again, because there are increased risks with physical activity, just because of faster movements, heavier lifting, that type of thing. Same thing with having special waivers for volunteers who drive. We also recommend, if you are doing any type of fitness activity, to use the same standard language we've talked about in the waivers, but also in addition to that, have specific language for the fitness activity. So for example, you want to have them attest in writing that they have prepared for using the equipment and facilities, that they haven't been advised to not participate by a qualified medical professional, and then that to the best of their knowledge, they're in good health and suffer no physical impairment that would prevent them from participating in that activity. And again, that's just because of the increased risks, and that's why that's recommended. And that's the kind of same line of thought that goes with events. If you are doing a fundraiser and you're serving alcohol, or you have an event that has a bounce house, or you're running, like we talked about earlier, if you have a running Sunday school that has a playground, the kids will be using it. Those, again, there's just increased risk. So you want to make sure that for those that you have waivers, if you can give written waivers. But if it's an event and it's not feasible to have everyone sign it, at least having liability in rule signage. So for example, if you're going to have a beer garden at a fundraiser, have big signs that no one under 21 is allowed to enter, that you enter at your own risk, that management is not or the organization's not responsible for serving alcohol. Ideally you're using a third-party vendor and transferring risk for liquor liability. So if you are having any special situations, again, you want to make sure that those are being addressed. And then if it is a situation where it's not feasible to have everyone sign a waiver, you at least want to make sure you have some type of liability signage. And again, that is not necessarily to prevent lawsuits. It's just to shift that burden of proof of, okay, well, you just entered an area that said enter at your own risk. And then, let's say it's a bounce house. You got injured on the bounce house. You should have known going into it, because of the clear and conspicuous signage that we posted, that this was going to be a riskier activity and that you had agreed, that you should have accepted that risk. Again, not going to prevent a lawsuit, but it will shift that burden of proof, and they'll have to prove gross negligence versus if we didn't have that event waiver or liability signage.
Sarah, thank you for mentioning the liquor liability. Most of our folks on this call are adverse enough to alcohol and the effects of alcohol. However, James and I are seeing a slow increase annually in events run by missions where they are serving alcohol, and it's really easy just to miss the risk transfer part that goes along with that. So yeah, thank you for highlighting that.
No, absolutely. The next one, a special consideration we're going to talk about is field trips. So field trips is if you're doing an activity with minors and you're actually transporting them to and from the event, whether it's your ministry members transporting them, whether it's volunteers, or even if you hire a third-party transportation company that's has buses or passenger vans that are transporting minors. That does also need some special language. And that's why, before I had mentioned if you're doing activities for minors to do permission slips versus doing a liability waiver. And if you are doing a field trip and it's involving transporting minors, there are some special language that we recommend including. And that way it's in plain statement that the parent or legal guardian authorized the organization to transport their minor from one specific location, and the waiver should have the specific location, to the next specific location and back. It should also describe the method of transportation. Claims that involve minors in getting into an auto accident are very tricky. And so we just want to make sure that we have it in writing, that the parent or legal guardian knew exactly where we were coming from, where we were going, and how we planned to get there, and that we had their permission to do it. And then another thing we recommend including in permission slips, and it's not for liability transfer, it's just really for the safety of the minor participants, is a medical authorization form. And that is just the parent signing saying, if my child needs medical care, that I authorize them to be transported to a hospital or to a nearby doctor and receive emergency medical treatment. It depends on the severity of the situation, but sometimes for serious injuries that may not be life-threatening, doctors, hospitals, medical providers are hesitant to and sometimes won't treat that patient until they get the parents' permission. And that actually happened to me when I was a kid. I broke my growth plate in my arm snowboarding and had to wait in the emergency room for 8 hours while my parents were skiing on the slopes until they finally saw the emergency flashing signs for them at the ski lifts to come give permission for me to get a cast on my arm. So that's probably why I added this in here, is from personal experience. But if we have it in writing that the parents authorize it, it can get them that treatment sooner. And then also, if you have to transport them to the emergency room or to a medical facility, we already have it in writing that the parent authorized us to do that, and then we don't have to call them and worry about any potential liability there. So it's good to have that built in. And then also, again, not for liability transfer, just for their safety, I do recommend getting at least one emergency contact for minors in case something does happen. If they do get injured, if they get sick, if something does go wrong, we know who to contact. Ideally, we'd have two contacts, so there's a backup, and that way we can make sure that if something does need to happen, that we can get a hold of the parent or the legal guardian right away. Another consideration is if you are doing a volunteer program or you are hosting an event and you're taking photos and you intend to use those photos or videos or quotes in not marketing materials, but let's say fundraising materials, or you want to use them for your website, or you want to use them in a mission statement video. There can be liability for organizations if you use someone's image and likeness without their permission. So if you do intend to do that, I just recommend including a media release in the waiver, and just have the person agree in writing that they're releasing all, any rights they have to quotes they've given, photographs that they're in, audio or video recordings that they're in, and that they're giving you permission to use that for promotional or educational materials in all forms of media. And like we talked about earlier, again, we're just trying to create a broad umbrella that would fall under anything. And again, if your intent is to record or capture anything that's happening and use it again and reproduce it in the future, I do recommend just including that in the waiver, and that way someone doesn't go on your website a year from now and say, what is my face doing on the homepage? And then you end up in a tricky situation when their attorney calls you. So if you do intend to do that, again, best practice to get their permission and get it in writing that they agree to give you permission to use them, and also release you from any liability from using their image, likeness, or voice recordings or video recordings.
And Sara, can we wrap in a lot of these into one document, or are there any things that should be a separate document?
You can wrap it all. Yes, you absolutely can wrap it all up into one document. That's not uncommon, especially with permission slips. They're usually at least 2 pages long, if not 3 or 4. So you can. The only thing I would say is that if it is something critical, to put it in bold, or sometimes even put it in bold in a different color, like red, just to draw their attention to it. And I think one of these slides we will go over sample language, so I'll talk about an example like that. But the only thing we want to avoid is a plaintiff's attorney arguing that we snuck in some type of release into a lengthy document because we were trying to hide it from them. So something like a media release isn't going to be as severe, but again, you don't want to get caught up in trying to make it look like you're hiding something. So as long as everything is in plain English, that it's clear, and if it's something pertinent, that it's in bold or a different color, you should be okay. Again, I do recommend consulting with your attorney, just because they'll know the local laws, the judges, how they interpret these types of things. But that's really the only issue when you create too lengthy of a document, is that argument that things are getting hidden inside. But again, if everything's in plain English, and some waivers even have the person signing it initial after every single clause, and that way they can't argue, oh, you tried to sneak this in, because and I do believe I have that on the sample slide, you'll see, but it is just to say, okay, I read this, good, I read this paragraph. As you move through the document, again, that's to avoid that they snuck this in there, so hoping that I would overlook it. That's a great question, James.
Awesome. And I think I'm trying to get to the next slide. Yes.
So in line, just like I mentioned with events where it may not be realistic to have everyone sign a waiver, for some of your ministries, you may have amenities that you're providing for clients that it would be great if we could have them sign a waiver for, but sometimes with people moving in and out, it's not realistic to have them all sign a waiver before they use the laundry facilities. So if you do have any common areas that are used by volunteers or clients, do think through those risks. And just like with the events, post liability signage and post rule signage. So for example, if it's a fitness center, you'd want to have instructions on how to use the equipment next to it. If it's a laundry facility, you'd want to have instructions on how to use the equipment, reminders to clean the lint tray before and after each use, posting what hours they should be in there. So if they should only be in from 8 a.m. to 8 p.m., those hours should be posted. So that's what we mean by rules. And then if there are any safety requirements or age restrictions, we want to make sure that's clear and that's posted. And then the liability language of use at your own risk. The organization is not responsible for any injuries or damage you incur as a result of using this. That type of big language, again, to shift that burden of proof, because there are just some inherent risks. You know, your property could get damaged using a laundry machine. You could have your clothes damaged, or there could be they may overflow the machine and cause a leak and then slip and fall. There are just things that could happen and could go wrong that isn't anything necessarily grossly negligent that your organization did, and we just want to make sure that it's protected. So again, do a walkthrough of the facility building. If you do think there are any special areas, just check and make sure that there's rules posted, any safety signage that needs to be there is there, and then that there's liability signage as well. And then I also just recommend in those common areas, if there is a safety feature, the volunteers and the clients will have a reasonable expectation that safety feature is working as intended. So if there's a fire extinguisher, for example, in a community kitchen, they have a reasonable expectation that fire extinguisher will work if they go to use it. Or if there is a security camera in the building, this is a big one because we've seen a lot of security related claims, they have a reasonable expectation that those cameras are on and working. We have seen claims come in from security cameras because people either got assaulted or they got maybe their car broken into, and they asked for the security camera footage and it's not there because they find out that it was dummy cameras. And then they file a lawsuit and allege that had they had that footage, they could have given it to the police, potentially found the person who either caused them injury or caused them property damage, and they could have been made whole. Now they had that reasonable expectation. Now they can't do that. And I haven't seen one of those claims go to court, but I have seen several of those claims come in, and the insurance carriers have paid out every single time because they agree that if you have it, there is a reasonable expectation. So these are great features to have. Safety features are a great risk mitigation tool, but again, it does create that reasonable expectation. So I just recommend that you add that to site staff's regular hazard identification checklist, just to make sure that everything in there to protect people is actually working as intended. So now we'll go through some of that sample language that I talked about. So this paragraph here is what the insurance adjusters and most attorneys, I should say, like to see. It's the paragraph that just says that, you know, the person signing it agrees to assume all risk. They agree to hold your organization harmless from any and all injuries, and not just your organization, but your officers, directors, employees, representatives, other volunteers, because we want to make sure we're not just protecting the organization itself. We want to make sure we're protecting the individual employees, the other volunteers. Again, the purpose of this waiver is to say, you know, there are some inherent risks. You're voluntarily accepting them. And we don't not just want them to come after the organization, but not come after anyone associated with the organization as well. Sorry, James, you could pull up the next slide. I should have given you a better cue.
No, I have to click and then get it to go, and it's not. There we go.
Perfect. So this is what I mentioned earlier, where I said some waivers I've seen, the ones that I like, have the volunteer or client signing or just initialing, after every paragraph. Again, that's to prevent the argument that we try to sneak something in there and make sure that they actually read through it. So that first paragraph I showed, like I said, that's what attorneys and insurance adjusters love to see. Also, though, like I mentioned before, we also need things in plain language and not just use terms like indemnification and hold harmless, because again, most courts don't think the average person would know what that means, and they're probably right. So this is other language that should be in there. So just plain as day stating, I understand, you know, my participation as a volunteer involves certain risks. That includes injury, death, property damage. I agree that I'm voluntarily participating with the knowledge of the, you could say danger, you could say risks, any layman term word there would work, and that they agree to accept all of those risks. So again, it's a reiteration, but it is to avoid some of those pitfalls that we see where a waiver doesn't hold up, because it's all insurance and legal jargon, and no average person could be expected to understand what that means. And then the next one is, oh, perfect. Thanks, James. Thank you. So the next one is the one we talked about with medical costs. So you can do a variety of different language to get this in. This is just one example that just says, they understand the organization doesn't contract with any medical services to provide medical care or treatment, and that should they require it, the key part is that should they require medical care or treatment, they agree to be financially responsible for the costs incurred as a result of such treatment. And you don't have to include it, but some organizations like to include that the person's aware and understands they should carry their own health insurance to cover costs for medical care or treatment. And that's that line there is just to make it clear to that person that, okay, the organization doesn't carry health insurance for my benefit. If I want that coverage, I understand that it's gonna have to come from my end, not their end. And really, the key here is, again, just make sure that we have it in writing that they agree to be responsible for medical costs. This page is more of some sample language about how to state things in plain English. So the first one, I understand and agree the organization's not responsible for any injury or property damage arising out of the event or program, even if caused by their ordinary negligence. And again, ordinary negligence does happen. Sometimes people forget to put a hose away, if they're working in a community garden and someone trips over the hose. Those are things that are really general, ordinary negligence. But again, waivers don't protect us from gross negligence. So if one of the employees attacked a volunteer, for example, that would be willful misconduct. Waivers are not going to protect from those types of situations, but they can provide a layer of protection for general and ordinary negligence. And you can put that language in there to be able to shift that burden of proof that their injury was caused by something beyond that ordinary negligence. And then the last one, the two things I wanted to point out here on this one is the first one, a statement that says that the person understands that the document is a contract which grants certain rights to and eliminates the liability of the organization. I usually recommend putting that at the very end and putting it in bold. Just so that they cannot argue that they skipped over it, and again that they cannot argue that they didn't understand that the waiver was a contract, because I have seen that argument made in claims before. They said, oh, I just signed it like I sign waivers when I go on a website, or waivers that I sign when I get a credit card, that type of thing. You do sign up for things sometimes and they ask you to sign a user agreement and waiver, and they're 20 pages and people are just used to clicking through those and accepting them. So to try and prevent someone from arguing that that's what they were doing, they thought it was just a casual part of the process, that it wasn't a legal binding document. From a claims perspective, I do recommend putting it in bold and just making it clear to the person, this is a contract, this is granting us rights, and it is eliminating our liability. Again, just to prevent that argument from being made. And then the last thing I wanted to point out is the participant signatures. So earlier I talked about if it's a minor, you want to make sure that it's their parent or legal guardian. I do recommend, even if it is supposed to be adults only, that they should be 18 and older, just putting underneath their signature line that they are of legal age and they're freely signing the document, and that they understand what it is that they are signing, and that they're giving up some legal rights and remedies. Again, I know it seems redundant, but being able to get it in writing that this person, said that they were legal age, that they're freely signing this, that this is not something that they're being, that they're forced to do, that they are volunteering, or they're voluntarily participating in our program, is key to put in the waivers. So that was talking about waivers and how we can create a situation where the burden of proof is on the plaintiff if a lawsuit is filed to show that we were grossly negligent, which is a very good liability protection and can lessen our liability greatly. But as I've said in some of the past presentations, the best claim, or the easiest claim to handle, is the one that never occurs in the first place. So if there's a good risk management program in place, it should reduce the chance of us even running into a situation where a volunteer or a participant or client is injured. So some of the general best practices are to have a volunteer coordinator, or at least an employee to provide supervision over the volunteer activities, just to make sure that everyone is being safe, that if they, that they're familiar with the operation the volunteers are doing, and if they see them doing something unsafe that could lead to an injury or could lead to property damage, that they're able to step in and educate that person on the right way to do it so that we can try and prevent that injury from happening. Another one is screening volunteers. I know James talked about that earlier. Having volunteers complete an application, and then if they're working with minors or other vulnerable populations, or if they're driving regularly, that's going to have an even more increased risk. So doing a background check, if they're working with minors, checking the sex offender registry, if they'll be driving, checking their motor vehicle record, that could potentially help us catch some red flags for people who we would not want volunteering on behalf of the organization, because it's a danger to the people you serve, but also poses a liability risk to the organization.
Yeah, and just to kind of reiterate our current paradigm on this is, we're encouraging a national background check screening of any regular volunteers. I know of one ministry that calls them mission-driven volunteers, folks who are there regularly, maybe even weekly, building relationships with clients. Those are the folks we really want to screen. But, folks who are just coming once or twice a year to do a cleanup or to serve a Thanksgiving dinner, who are constantly supervised by employees, we're not necessarily looking for them to be screened.
Perfect. Thank you, James. I appreciate that clarification, which is good, because you're right. It's not feasible to do all the time. It's just when we have those increased risks is when it's best practice. Another one is creating policies and procedures. So making sure that there's something in writing volunteers can review ahead of time so that they understand what's going to be expected of them, either during the duration of program or during a special event that's being done where they're maybe just doing a one-off volunteering for a day, and make sure that they're getting practical information about what their responsibilities are, what your policies are, and what the safety expectations are, and one, for their safety, right? So that they know what it is that they need to do to keep themselves and others safe. But also, we talked earlier about situations where people claimed that, they, got hurt volunteering or participating in a program. And had they been told how to do that activity correctly, or had they been given some type of safety rules, it wouldn't have happened. We want to prevent those arguments from being made. So getting it down in writing what the safety rules are, what the expectations are. Also, getting it down in writing what the responsibilities of the volunteers are is good, because we have them sign this waiver that says they understand the inherent risks and they agree to accept them. We strengthen that argument when we have a volunteer handbook or a volunteer description that says what it is they're expected to do. And that way we have even more evidence that says, okay, they knew what was expected of them. They knew what could go wrong, what safety rules were in place, and they voluntarily chose to do it. So having those policies and procedures can help with that as well, in addition to keeping people safe. And then finally, having a code of conduct or ethics for volunteers, either as a standalone policy or in the volunteer handbook, is best practice, because volunteers do represent your organization to the public, and they should be accepting responsibility for that role, for that status. And we should be expecting these volunteers to conduct themselves in a professional and safe manner at all time. And so that's for that reason we recommend, it doesn't have to be robust, but just having some type of code of ethics as part of the volunteer handbook, and even having the waiver, having them agree that they will abide by not just the safety rules that have been laid out, but also the code of ethics.
Yeah, and as part of that, I and correct me if you think this should go in a better place. It may be something that has to do about the social media policy of volunteers. Obviously, you can't control what a volunteer posts, but we probably should be careful that volunteers aren't posting pictures of clients on social media without that client's permission. To the extent that you can say, hey, no pictures of clients' faces on social media, that's probably ideal. But that's kind of related to the, hey, we don't want someone's name on a marketing piece or their face on a marketing piece without their permission. We also don't want someone on social media then saying, well, I didn't want people to know I was staying at the mission, and now they do because my face is on social media.
I'm glad that you brought that up. That is a perfect example of something that should go into a code of conduct or code of ethics that can prevent some issues. That's a great example.
And we have just a handful of more slides. We're running out of our allotted hour, mostly because I keep interrupting Sarah. I think we'll be able to wrap up in another 5 or 10 minutes. If you need to jump off for another call, we are recording this. We will send it along with the slides to everyone who's kind of on our distribution list. But certainly if you want to write John or I directly, we can also send it directly to you as well.
Perfect.
So
And
back to you.
I'll go through these next couple slides quickly because I know the fun insurance slide is coming up, and John, I probably have some great insight to share on it. But in line of trying to prevent incidents from happening, it is also best practice to, especially when people are working at a site, just to do a site walkthrough to try to look for hazards that could lead to an injury and prevent them. That really is what the risk management process is. It's identifying hazards, assessing, seeing what could go wrong, finding a way to either mitigate or eliminate it. And then implementing that control and making sure that it's effective. And if it's not, coming up with another idea and keep going. But a lot of times I find sometimes there'll be like a volunteer program to work in a storage room. And the first time someone's been in there in weeks is when they walk in with the volunteers and turn the lights on. So I just recommend making sure that you're having site staff do walkthroughs of the areas where the volunteer activities will be taking place or the event with the clients, and just looking for common things like trip hazards, slip hazards, maybe a light fixture dangling from the ceiling that could fall, those types of obvious things, and correcting them before the program even starts. And you can jump ahead to the last slide because I think we've talked about a lot of that already. So okay, perfect, because this is the good stuff. So obviously things can go wrong. If something does go wrong, what insurance coverage is in place. So I'll briefly talk about the two main policies that would respond if someone were to be injured or have their property damaged as a result from either a volunteer program or a program for clients. And then I'll let James and John chime in with their insightfulness from their end. So the first one is the commercial general liability policy. So for those that don't know, this is the policy that responds to third-party bodily injury and property damage. So if someone else gets injured or if someone has their property damaged during the event, during the program, and they file a lawsuit against you, this is the policy that's going to respond. The slide says in theory it would respond, and that's just because policies do have some exclusions. For example, a really common one is mold. If someone says they have respiratory issues because they were working in a room that had mold in it, that can be excluded on some policies. So I can't promise you that it's going to cover everything, but for most general negligence claims, what we're going to see, this is going to be the policy that responds. Sometimes those policies have what's called a medical payments coverage. And what that is a no-fault coverage where if someone gets injured, much like the volunteer insurance I mentioned earlier, it will reimburse out-of-pocket medical expenses up to the limit. The only thing I wanted to mention for medical payments coverage is that there's a misconception sometimes that if medical payments coverage kicks in and reimburses someone for out-of-pocket medical expenses, that person then can't file a lawsuit for more damages. I do want to say no one is required to sign a release to file a lawsuit against your organization if they accept medical payments coverage or if they accept a medical reimbursement under the volunteer accident policy. What that coverage is designed to do is to get someone reimbursed quickly for those out-of-pocket expenses and make them whole to try and then prevent them from filing a lawsuit. Versus if that coverage wasn't in place and they say, oh gosh, like hiring an attorney may be my only way to get reimbursed here for these expenses. That's what we're trying to avoid are those scenarios. So that's the difference between that medical payments coverage and that volunteer accident and the general liability. Is the general liability is to cover your liability. So someone has to prove that you're liable, or the insurance carrier has to at least believe that liability is there to pay out the claim, versus that med pay and volunteer accident. That's a no-fault coverage that's just going to automatically kick in. But again, it doesn't prevent a lawsuit in the way that if a general liability claim was settled, the insurance carrier would be sure to make sure that there was a release signed that they agree not to file a lawsuit.
Yeah, thanks, Sarah. And many of you already buy into the Citygate Network's master accident policy. It's a group policy. It renews every August 22nd. And so usually in July, you hear from us to update your one-page form. And that's the form that we use to most of the time in ensuring a resident volunteer, i.e. a client who's doing work therapy, but also a non-resident volunteer, especially for those of you that have more mission-driven or volunteers who are involved regularly. And, you know, whether a client has private health insurance, most don't, but some do, or Medicaid, again, some do, some don't. This is on the volunteer insurance will pay whatever medical bills are unpaid by Medicare excuse me, Medicaid or whatever other insurance they have. Same thing for volunteers who, you know, might be on a high deductible plan and maybe their cast costs them $600 out of pocket. You know, we've paid for those bills as well. So that coverage is presently with the Hartford. They've been good to us so far. We have a couple claims every year, and sometimes a couple every month. But we think it's a great way to just kind of take care of medical bills without the potential threat of litigation.
Hey, Sarah, we have a couple of questions that have come in. One, how long should you, or how often should you have a volunteer re-sign a waiver? And how long should waivers be kept on file?
Great question. So for how often you should have the volunteer re-sign the waiver, it's going to depend how the original waiver was worded. So for example, some waivers will have at the very top line items where the participant will fill out their name, their contact information, what it is the waiver's for. So either the volunteer program or the client program, and then it'll have effective dates. So sometimes it'll be, you know, a year-long program that maybe a client's participating in, and those dates will be specified. Other times, same thing with volunteer programs, there may be a specified time frame. If you have that specified time frame, that's fantastic. You don't need to keep constantly having them re-sign waivers every time they come in. If someone's doing a one-off volunteer work and it's for a specific event or program, and then they come back and they're doing it for a different program, or it's been over a year and it's not really connected to what they originally were working with, that's when we recommend having them sign another waiver, because most of the time, like I mentioned earlier, these waivers are not blanket. They're not going to cover everything. So as long as they're still volunteering or they're still participating in the program for which the original waiver was signed, then that will work. It's when they start doing something different or outside of the scope of those original volunteer duties or the original program where you would want them to have another waiver signed. And for how long you should keep the waivers on file, it's going to depend on the statute of limitations for bodily injury in your state. So some states are 2 years, some states are 4 years. Some states and most states, if it's a minor that's injured, they have until 2 years after their 18th birthday, which I know is a long time. But my recommendation is to understand what the statute of limitations for bodily injury or third-party property damages in your state. Keep it for at least that long on file, even if it's just a scanned copy, being saved on a server somewhere. And then I also recommend tacking on additional time, because sometimes and we see this a lot with fraudulent claims, the attorneys will file the lawsuit the day before the statute of limitations expires, and then they'll wait to serve it. And sometimes they'll wait until the judge orders them to serve it. And I've seen it served months after the statute of limitations wouldn't toll. So talk with your attorneys about what's common practice in the area and how long you should keep it. But I would recommend as a baseline at least a year after that statute of limitation tolls. And that way, if you do get hit with one of those fraudulent claims that comes at the very last minute, sometimes after the hour, that you still have that on file.
Good info. Thank you. I will also note that for those of you who have boxes and boxes of waivers that are signed, it may be challenging to find the right waiver. So it may be worthwhile looking into a digital storage system and some way of being able to search to be able to identify where that waiver is for that volunteer that that is coming back to you 3 to 5 years later and saying, hey, I volunteered and this is a problem, or showing up as a lawsuit. We have another question from Sanjay. Can we deny someone from volunteering if we think that they are not a good fit after initial screening? And secondly, can someone claim discrimination if we do not let them volunteer?
That's a great question. So I guess it depend on the reason for why you are not don't think they're a good fit for your organization. So for example, if so it was a driving position, either transporting people or goods, and they had a poor driving record, or they were working with children and they're on the sex offender registry list, absolutely you can. The only thing is you want to make sure you're in compliance with the Fair Credit Reporting Act. If that's the reason you're going to be denying them as a volunteer for your organization. So the Fair Credit Reporting Act requires you first, if you're going to do a background check, that you obtain someone's written authorization to order that background check report. And motor vehicle records, just so everyone knows, is considered a consumer report under the Fair Credit Reporting Act. So those require the same type of written consent as any other background check would. And then if someone is going to have an adverse action taken against them, in this case, not being allowed to volunteer for the organization, the FCRA does require that person be provided with a written notice that the adverse action is being taken, as well as pointing them to where, which agency it was that did the background check. So whether that was a third-party vendor, or maybe for MVRs, it could be the state's Department of Motor Vehicles, and that way they can and also give them notification of the rights to receive a copy of that report. So there are some compliance issues when denying someone for those reasons with the FCRA, that you want to make sure that you're meeting those compliance needs. But yes, you absolutely can. You just want to be careful if it is because of a background check, that you are following the FCRA's regulations that they've set forth. And we do have sample background check policies and background check consent forms. We don't have a sample adverse action notice, but SHRM, the Society of Human Resource Management, who is one of my favorite HR organizations because they have so many great sample documents, they do have sample adverse action notices that are for free on their website for you to download and use. As with all things, we do recommend it be run by your attorney, but if you do need sample adverse action notices, SHRM does have some good ones. Okay.
James, there is one question. James and Sarah, you guys may want to tag team on this one. What is the difference between general liability coverage for bodily injury and volunteer insurance coverage for any uninsured medical expenses? Does one kick in first before the other?
Yeah, I would say you at a very high simplistic level, usually the volunteer insurance kicks in first, because when something happens, first we have a medical bill. And we're using the volunteer insurance to cover that medical bill. And we're hoping that it goes away. But if it doesn't go away, then we're bringing in the general liability policy.
That's a good answer. So I don't have really too much to add, other than, again, yeah, one's that no fault coverage. The other one, your liability for the injury would have to be established. And ideally, any med pay or volunteer, like James said, would respond first and hopefully prevent a general liability claim. But if that doesn't happen, we have that additional layer of protection.
All right. I cannot see if there's any other questions. So anything else we want to say in closing, John?
I don't have anything else. Joseph and Joni, James and I will make sure we get that this presentation to you along with some samples. We should be able to get that out this afternoon. Thank you so much, everybody, for your participation.
Fantastic. Thank you. And Sarah, thank you so much. This is the last of Sarah's trio for us. We're going to have another session on cyber insurance with a different partner of ours, but we will be seeing Sara later this summer for more risk education. So Sara, thank you so much for the investment you've made in all of these ministries. We really appreciate it. And I know I've gotten a lot of feedback offline about how helpful this has been. So thank you again.
Oh, that's great to hear, and it's absolutely my pleasure. And if anybody needs support moving forward with anything risk management related, please feel free to reach out to James and Jon, and I'm sure they'll be able to get you connected with me, and we'll get you the support that you need.
Awesome. Thank you all. Thanks for what you do. We'll talk to you soon.